Little record icon, we will go. And please remember, we'll be muting you along the way. Let's talk with people not realizing they're not muted.
We're live, Ms. Longden.
All right, great. So, all right, Democratic Caucus has now come to order. Let's get started. So our first bills are going to be Ben and Nicole. Ben, Nicole, please turn your cameras on. Hello, Ben. How are you today?
I'm doing lovely. How are you?
I'm great. Let's start with 2142, please.
Thank you, Madam Chair, members. HB 2142, Agricultural Workforce Program, Apprentices and Appropriation. This bill establishes an agricultural workforce development program to incentivize food-producing agricultural organizations to hire apprentices. It requires the Director of the Department of Agriculture to establish rules for the program. These rules must establish qualifications for the food-producing agricultural organizations to participate in the program, including supervision requirements for their apprentices and the need to provide apprentices with meaningful work experience. To provide a preference for food-producing agricultural organizations in rural and tribal areas or historically underserved farmers and ranchers, and rules that require a participating food-producing agricultural organization to pay apprentices at least the state minimum wage. The rules would also establish criteria for food-producing agricultural organizations to select qualified applicants. The bill would establish the process and time for selecting the rules would establish the process and time for selecting qualified food producing agricultural organizations and apprentices. It would require that the department establish accounting requirements for tracking apprenticeship costs. It would allow the Department of Agriculture to reimburse a participating food producing agricultural organization up to the actual cost of employment. It would allow the Director of the Department of Agriculture to determine the number of apprenticeships to approve, including whether it would approve more than one apprentice per participating food-producing agricultural organization, and the amount of reimbursement based on the appropriation to the program. Requires an annual report on the effectiveness of the program, and sunsets the program in July 1st, 2027. It defines the actual cost to mean the wages paid to the apprentice, as well as reasonable fixed overhead and incidental costs. And it defines an agricultural organization to mean a business, a nonprofit, or a community college or state university program related to agriculture. So it's very broad. It defines historically underserved farmers and ranchers to include beginning farmers or ranchers, socially disadvantaged farmers or ranchers, or veteran farmers or ranchers, as that's defined in the U.S. Code. It would appropriate $500,000 from the general fund in both fiscal year 21 through 22 and 22 through 23 to the Department of Agriculture to implement the program, and it would exempt this appropriation from lapsing. It would set the effective date of the program for December 31st, 2021. And with that, I can answer any questions.
Thank you, Ben. Okay, let's, Sarah, was that your hand up? No? Okay. Okay, let's move on to 2188, Pest Management, Unlicensed Business Activities. Ben.
Thank you. Madam Chair, members, HB 2188, Pest Management, Unlicensed Business Activities. This bill creates a list of persons engaged in the business of pest management without a license and sets penalties for these violations. It would enable the Director of the Department of Agriculture to educate the public on the pest management licensure, certification, and registration requirements. Would authorize the Director of the Department of Agriculture to maintain a list of persons who have engaged in the business of pest management, commenced work on a contract, or signed, issued, or delivered any document expressing an opinion or statement relating to pest management without the appropriate license. This list would be maintained by the Department of Agriculture on their website, and would also come with requirements that the Director remove a person from the list within 10 days after they have become licensed and requested such. The Director would also provide a copy of the list to any member of the public who requests it. The bill states that any person who engages in the business of pest management or commences work on a contract without a business license under the pest management statutes, unless they're exempt, would be guilty of a Class 2 misdemeanor. And I would note that that's already a crime if done with reckless disregard for health and safety. That's a Class 6 felony. It would just remove that mens rea requirement that if you did it at all, that would be a Class 2 misdemeanor. And with that, I can answer any questions.
Ms. Powers Hanley.
Thank you, Assistant Leader Longden. So do we do this for any other professions? It seems like we are open for business on everything else.
Madam Chair, Representative Powers Hanley, I do not know that if we do this for any other professions. I can certainly find that out and follow up with you.
Thank you.
Anything further, ma'am? No? Okay. 2289, Citrus Research Council fee increase. Ben.
Thank you, Madam Chair and members. HB 2289 Citrus Research Council and fee increase would increase the amount of fees that may be collected by the Arizona Citrus Research Council for produced citrus and allow for different costs for citrus produced for the fresh market as opposed to citrus produced for juice. Would extend the definition of citrus in the statute to include varieties of the genus citrus that are produced for juice production. Previously, it was just the fresh market. It would increase the maximum fee that the Citrus Research Council can collect per standard carton of citrus. That's a standard within the industry, or its equivalent, from 1.5 cents per carton to 5 cents per carton. It would allow the council to assess fees for citrus produced for the fresh market and citrus produced for the juice market at different rates, and then of course acknowledges the need to comply with Prop 108. And with that, I can answer any questions.
Okay. 2003, forest proper management. Ben.
Excuse me. Did you say 2303?
No, I'm sorry. 2003.
Understood. Yes, HR 2003, Forest Proper Management, is a House resolution. This resolution details the harms that are caused by forest fire and inadequate forest management in the state and the Western United States as a whole. I would note that it does hold environmentalists and protection of endangered species as the culprit for improper forest management here in the state, details the dangers of future forest mismanagement and wildfire, and resolves that the House prioritize forest management and expresses support for landscape scale planning, forest thinning projects, and acceleration of consensus supported and scientifically informed forest restoration treatments. And with that, I can answer any questions.
Okay, hands are going up on this, and I see that there was some division on the vote in committee. Mr. Sierra, your ranking member, are you in a position to talk about this bill?
Yeah, as Mr. Bryce mentioned, the HR it does put blame on environmentalists and the spotted owl, so I voted no. And unless I think Representative Epstein might have a amendment on it.
All right, thank you. So there are 4 hands up in this order. We're going to go Epstein, Shaw, Germain, D'Alessandro. Ms. Epstein.
The amendment tries to adjust the language so that the environmental groups are not blamed for things they did not cause. And it specifically talks about the importance of protecting large diameter trees, which is a very important part of actually protecting our forests from wildfires.
Thank you, Ms. Epstein. Shaw.
Thank you. So what I don't understand is that language, the blaming language. What is the effect of putting blaming language into a bill? I guess I'm not really understanding what impact that has. Doesn't that usually fall into a resolution of some kind? But what does that have to do with statute?
That point.
Are you waving it off, Sierra?
No. So I'm answering the question. It's a continuing resolution, Dr. Shaw. It's not a statute.
To that point, the trouble with
it is a resolution. I'm sorry, I apologize. It is a resolution. Okay.
To that point, Ms. Epstein.
When we put falsehoods into resolutions, it makes them look official, like these falsehoods are true, and they're not true, and that's why we must fight against them.
Mm-hmm. Right. I think that Shaw missed that it was a resolution, not a House bill. Germain.
Has there been previous money in the budget for forest management, or are we just throwing around blame without actually paying for forest management?
Ben? Ben?
Excuse me, sorry, I was fighting with my mute. Yes, Madam Chair, Representative, there's currently a lot of work being done to incentivize this kind of forest thinning. Right now, there's been a few bills that have been moving through. Frankly, a big part of it right now is the difficulty in having industry that would be able to process this kind of forestry product. The smaller than 10-inch diameter trees that burn easily, as opposed to these larger diameter trees. As far as specific monies in the budget to deal with this, I would need to go back to check exactly what those are, but I'd be happy to follow up.
Thank you so much.
Thank you, Ben. Ms. D'Alessandro?
Thank you so much. I voted yes in hopes of Representative Griffin accepting Representative Epstein's amendment on the floor and Cal, if that's appropriate. And I'll be a no if there's no amendment to it.
Thank you. All right. Moving on, HB 2249, state land leases, renewal applications. Ben.
Thank you, Madam Chair. Members, HB 2249, state lands leases renewal applications, requires the State Land Department to accept land lease renewal applications by mail, allows the State Land Department to accept land lease renewal applications electronically as well, prohibits the State Land Department from considering the method of renewal that an applicant uses to submit their application when determining whether to renew a lease, directs the State Land Commissioner and the Director of the Department of Water Resources to develop a plan to create additional water storage in the state, to investigate potential water shortage sites, and to identify at least 6 of the most potentially acceptable sites, clarifies that water storage sites may be underground or above ground, requires the State Land Commissioner and the Director of the Department of Water Resources to submit a report of the department's activities, findings, and recommendations to the Governor, the President of the Senate, the Speaker of the House, members of the Senate and Water and Agriculture Committee and the House ENRU, and the Secretary of State by December 31st, 2021, and sets a delayed repeal of this section for that section requiring investigation into water storage by December 31, 2023. And with that, I can answer any questions.
Excellent. Dr. Shaw?
I'm missing, what happened to 2248?
$22.48 is not currently on our caucus sheet, Dr. Shaw. We're working on it.
Got it. I got the green sheet. Thank you.
All right. Perfect. You're good? All right. Mr. Andrade.
Yes, Madam Vice Assistant Leader. I just want to mention that all these bills are on third read consent, so if anybody wants to pull some of these bills. Thank you.
Point taken. I assume, Sierra, you're pulling 20003.
Yes, please, Assistant
All right,
Leader.
we got it. All right, Rhonda will be sending a sheet. And let me get to that now, please, as a reminder. Rhonda needs to fill out that form in order to pull something from third read consent. So if after caucus you decide you're going to have something pulled, please make sure you loop Rhonda in when you do that. Okay. All right. Thank you. And let's move on to HB 2329, air quality omnibus. Ben.
Thank you, Madam Chair, members. HB 2329 Air Quality Omnibus makes changes that are subject to approval by the United States Environmental Protection Agency, because this is part of how the state implements the Federal Clean Air Act. So of course, any action would have to be approved by EPA. But it would clarify requirements for vehicle emissions and broaden the authority of the Department of Environmental Quality to study and test vehicle emissions. So the bill repeals county voluntary vehicle repair and retrofit advisory committees and repeals their repair and retrofit programs, and instead establishes a voluntary vehicle repair and retrofit program administered by ADEQ. It removes the requirement that vehicles be at least 12 years old to qualify for this program, and reduces the copay required for vehicle owners that participate in the program from $150 to $100. It increases the cap on repairs from $700 to $1,000. Of course, anything more is the responsibility of the owner, and removes the requirement that a retrofit kit must be used for compatible vehicles. It simplifies and clarifies testing requirements for determining compliance with emissions standards in areas A and B. Those are areas set for Clean Air Act compliance, and allows ADEQ to make rules to exempt certain cranes and oversized vehicles and vehicles that are not used or that are not used or that are owned by state residents on active military duty outside of the state. It eliminates the state's catalytic converter program, broadens ADEQ's ability to study the effect of vehicular emissions and to hire consultants to analyze the cost and benefit of emission reduction programs, and to design, execute, and evaluate the results of these testing programs, and makes, of course, enactment conditional on approval by the EPA. And with that, I can answer any questions.
Okay, HB 2336, Assured Water Supply, subdivisions, Ben.
Thank you, Madam Chair, members. HB 2336, Assured Water Supply subdivisions, would modify the Assured Water Supply requirements for modifications to a certificate of designation of Assured Water Supply. It sets the following special requirements for an application to modify a designation of Assured Water Supply or a new application for a designation of Assured Water Supply for the same service area that's going to be served by a substitute acquiring the assets of the prior provider. The Department of Water Resources shall not review the physical availability of groundwater stored outside the area of impact of storage. And when I say area of impact of storage, that means specifically the area that is impacted by water being put into the ground to store long-term water storage credits. The Director of Department of Water Resources would not review the physical availability of groundwater stored outside the area of storage, of impact of storage, and the physical availability of groundwater and stored water outside the area of impact of storage shall not be grounds for an objection if the total groundwater and stored water to be recovered outside the area of impact of storage is not more than the sources of water in the previous designation minus the sum of withdrawn groundwater and withdrawn stored water outside the area of impact of storage of the previous designation. Essentially, if you're not going to use more water if you apply for a new designation of Assured Water Supply, then the department would not look at whether the previous designation was correct. They would not look at the water resources to be recovered outside the area of impact of storage. This bill also clarifies that this does not affect the Department of Water Resources review of other Assured Water Supply criteria other than the availability of groundwater and stored water outside the area of impact of storage. It deems the following to be physically available, which is a requirement of a certificate of Assured Water Supply or a designation of Assured Water Supply. Stored water to be recovered within the area of impact of storage on an annual basis, or as long-term storage credits to be earned in the future if the water to be stored meets the physical availability requirements for Assured Water Supply. And then it defines the area of impact of storage, as we talked about earlier, to mean within 1 mile of an existing or proposed underground storage facility where water is or will be recovered within the district boundaries of an irrigation district that has a permit for groundwater savings facility, or an area that has been shown to have a positive impact by storage of water by an ADWR approved hydrological model. This requirement would be limited to within the Pinal active management area, but it would also allow the department to apply these same requirements outside the Pinal active management area. For holders of a certificate of Assured Water Supply, this bill also states that a change in the total number of housing units or lots does not constitute a material change in the subdivision plat, plan, or map, such that a new certificate of Assured Water Supply would be required. Essentially, what this means is if you have a certificate and you want to change your map or your plat, then you don't have to go back to DWR to ask for a new certificate as long as you're not using more water than your current certificate would allow. And it states that changes to the number of housing units are not sufficient to require a new certificate of Assured Water Supply. This one is super water wonky, and so I'm happy to answer any questions. I know that was a lot.
Thank you, Ben. And this is a bill that is certainly not very well liked, especially by our members of the committee. Let's hear from Mr. Cano first, and then I see your hand, Dr. Freeze. Mr. Cano.
Thank you so much, Assistant Leader, and good morning, members. This is a bill that has historically, before the pandemic, it was a divisive vote. Certainly our caucus, the majority of us were opposed to it. And I think ultimately the stakeholder process has been about a 2-year stakeholder process. Mr. Lieberman, you are working on an amendment with the bill sponsor that I think might be able to ascertain some of the concerns from the folks who perhaps are opposed to this. And that's basically including language that if we know Pinell County needs some additional safety nets to ensure that there are adequate water resources, then why not put that language in this bill if you're going to use less water? And I think that's the spirit of the amendment, a technical change, but you know, we'll pay close attention to the cow debate, and I'm hopeful that our colleagues across the aisle will see this through.
Freeze, can I hear from Lieberman first on his amendment? All right, Mr. Lieberman.
Yeah, I mean, I just don't want to underscore what Representative Cano said. Essentially, the situation here is they have approval to build a bunch of houses with a big golf course that would suck up a lot of water. And people don't want to live around golf courses. It's like not that economically attractive. So what they're trying to do is to say, well, look, if we use less, can we get rid of the golf course and build houses there? I think the reality is, as the land has become more and more valuable over the last 9 months, it's about doubled in Pinell County. If they don't get this approval, they'll build the old plan and it will just be less efficient use of water. So that's really what kind of swayed me in the committee vote, with the commitment I said at the time. I think Andres and I were pretty close on this, that if they didn't make any change, I'd vote against it on the floor, basically. But they've been open to actually specifying that they have to come in and use less water with whatever their new plan is than what they otherwise would have done. And I think that gets me and hopefully some others comfortable with the fact that we're actually doing something kind of good for the world, because otherwise they build this much less efficient thing that would use more water than they would with this bill. At the same time, and I think Representative Rodriguez was actually a part of this, this really comes after a 2-year stakeholder process. Really, they did a lot of work to try to get to this point in a way that's reflective of a lot of the demands and challenges down there. So this seemed like a good compromise. The sponsor has been open to it, and you know, hopefully that nothing will happen. The amendment will get on, and we'll.
All right, thank you. I also realized that I've skipped a bill. We're going to go back for that in a minute, but Mr. Freeze, Rep. Freeze, and then Rep. Epstein.
Thank you, Assistant Leader. I think what Aaron just said makes a lot of sense. This bill doesn't have anything to do with agriculture. It's all about developers. Is that right?
Madam Chair, Representative Freeze, that's right. This bill is really designed to deal with the 100-year requirement for subdivisions within AMAs. So it's all about groundwater use by houses.
And I just want to point out to the caucus that people that living in houses use less water than agriculture. And I think what Mr. Lieberman said about, you know, taking out the golf course and putting in some more houses, as long as this amendment can clarify that they won't use more water, then that probably fixes things. Thank you.
Thank you, Dr. Freeze. Ms. Epstein?
I just want to be sure that this bill is considering a lot more than the water implications. I know in our district, we have a number of golf course owners who have purposefully turned off the water on the golf course in order to cause the land to have less value, and really violating the contracts they have with the houses around them to keep it as a green area. So there are private contracts involved in things like golf courses. So without reading the bill, it's just raising a lot of red flags for me when you're talking about golf courses versus houses on existing land. So let's be really careful about that. I'll talk with Ben separately.
Thank you. I see Ms. Stahl-Hamilton's hand. Mr. Cano, you want this pulled from third read consent?
Yes, please.
All right, thank you. All right, Ms. Stahl-Hamilton.
Yeah, just real quickly. So Senator Engel and I, because this bill was heard in the House, I mean in the Senate as well, and she and I spent a lot of time unpacking this. and the committee work that has been done is great, but truly at the heart, at the very bottom of all of this, what is holding this up and has been holding it up for 2 years is the water models that they are using to say there is or isn't enough water. Bottom line, there's not enough water for the 100-year supply. But what this bill does, it says we won't even look at those models because we need to move forward with this project. And the compromise was they'll use less water. But at the very heart of this, we're looking at water models and we're looking at available water. Truth be told, they'll probably run out of water in 80 years as opposed to 100.
Thank you, Ms. Hamilton, and welcome to NRU.
Can I just say to that point, I think it's super important that people understand you can't get, for exactly the reason Stephanie talked about, and she's completely accurate, you can't develop new plots of land right now in Pinal County because of that study. This deals with those that already have approved water supplies that currently assured water certificates that were previously awarded before that study. And that's a right the developer has currently and can't be taken away. So if we don't do anything, they'll go build the old thing and use more water. With this amendment, they'll have to do something different and use less water. But importantly, new subdivisions breaking new ground cannot, like that are proposed, they're not issuing any and haven't since they did that new model. But there is an underlying problem here that's not addressed by any of this, which is there's too little water in Pinal County. All of that.
Thank you. Last word on this bill is going to go to Dr. Freeze. Then we're going to save the rest of it for Cal.
Eric just cleared it up for me. These assured water supplies have already been issued. We're just talking about amending them to include more subdivisions, which in fact would use less water than the original plan. Did I get that right, Aaron? Yeah. Okay.
Correct. If my amendment gets on, right now it says they can't use more. My amendment will say they have to use less.
Thank you. Okay, so let's go back because I missed HB 2330, Environmental Quality Program, terminations repeal. Ben.
Thank you, Madam Chair and members. HB 2330, Environmental Quality Programs, Terminations and Repeal. This does not, I just want to make clear before I dive into it, does not repeal these environmental programs. It repeals the termination dates for these environmental programs. It moves the Oil and Gas Conservation Commission to within ADEQ. It's currently separate. It repeals the commission's termination date. It repeals the Vehicle Emissions Inspection Program's termination date, repeals the Voluntary Remediation Program's termination date, repeals the Total Maximum Daily Load Program's termination date, reestablishes the Monitoring and Assistance Program and Safe Drinking Water Program Fund with the following change. Previously, any surplus in the Monitoring and Assistance Fund would be used to reduce future fees. This bill changes that to any surplus over $200,000. Contains a retroactivity clause to June 30th, 2020 for the provisions of the bill that involve the Voluntary Remediation Program, Total Maximum Daily Load Program, and Monitoring Assistance Program and Safe Drinking Water Program. The reason for that is these programs expired, but were continued by Governor Ducey's executive order because these programs were held up because of the COVID, or these previous bills were held up because of the pandemic. And then contains an emergency clause that would have immediate effect upon the governor's signature. And with that, I can answer any questions.
Okay, let's go on to HCM 2001, Salt Cedars, urging eradication. Ben.
Thank you. Madam Chair and members, HCM 2001, Salt Cedars Urging Eradication, provides background on the introduction and proliferation of the salt cedar here in Arizona, lists a series of harms caused by the salt cedar, including high water use, replacement of native plants, etc. States that the elimination of the salt cedar would sustain water supplies, reduce the risk of environmental disaster, and lists a whole host of wonderful things that getting rid of the salt cedar might do. Then it requests that the United States Congress appropriate money to Arizona to eradicate salt cedars from Arizona waterways, and that the U.S. Department of Interior and the Department of Agriculture develop innovative solutions to control the proliferation of salt cedars, and then requests that the Arizona Secretary of State transmit copies of the memorial to the President to the President of the United States, President of the U.S. Senate, Speaker of the House, etc. And with that, I can answer any questions.
Okay, let's go on to HCR 2009, Hard Rock Mining Supporting. Ben.
Thank you, Madam Chair, members. HCR 2009, Hard Rock Mine Supporting. This bill acknowledges the central role of hard rock mining in the state's economy, the importance of copper and other minerals to renewable resources like solar and wind, that Arizona is a top producer of copper in the country, that copper mining, or excuse me, hard rock mining contributes $370 million in state and local tax revenues and $100.4 billion in economic impact to the state. That over 38,900 workers are employed by the industry, and that the industry is regulated to ensure employee, community, environmental safety. And so this would recognize the importance of hard rock mining in Arizona and resolve to support the involvement of Arizona's government in hard rock mining, in the hard rock mining industry, to ensure safe and productive operations continue. And with that, I can answer any questions.
Ms. Powers-Hanley, were you on this bill or the one previous? I looked up and saw your hand up.
Yes, I was actually on the one previous. I'm sorry, I was slow.
All right, can we answer questions on this one and then go back?
Yes.
All right, so Ms. D'Alessandro.
Thank you so much. I'm between a rock and a hard place. I support the current mines, but I'm a staunch opponent to the Rosemont mine, which would make my property and that of thousands of others in my district not worth anything because we wouldn't have any water. All of our water comes from groundwater. We don't get cap water down in most of Sahuarita and Green Valley.
Are you pulling this, ma'am?
No.
Okay. All right. Thank you. So let's return back to Salt Cedars. HCM 2001 for Ms. Powers-Hanley's question.
Yes, thank you, Assistant Leader Longden. I noticed that there's quite a few people signed in on RTS against HCR 2009, and I was wondering, are they against it because it doesn't do anything? It just asks for federal money and says, hey, we got a problem? I mean, just curious why there's quite a few people against it.
Madam Chair. Ms. Powers-Hanley, are you referring to Salt Cedars urging eradication 2001?
Yes.
Okay, got it. So I think it's just a philosophical debate about whether Salt Cedars are the problem for our diminished water resources throughout the state of Arizona. I'm speaking as one member to say that no, it's not just the Salt Cedars. Perhaps human consumption is a part of this. And certain industries, but you know, this is a postcard that we've seen and that we've sent out before. But I imagine that those requests to speak against would say something similar.
Thank you, Mr. Cano. Okay, HB 2246, GNF private lands, trespassing. Nicole.
Thank you, Madam Chair. House Bill 2246, Game and Fish Private Lands Trespassing, prohibits guiding and trespassing on private lands that are properly marked without permission. The bill requires signage to include the words "no guiding" if the landowner does decide to prohibit that. Finally, the bill removes the height requirement of the sign needing to be 4 feet above ground level, but still requires the other requirements of the language and them being 8 inches by 11 inches and the letters being in bold and 1 inch high. And the signs must also be posted at all vehicle entrances. And with that, I am open to questions.
All right, HB 2040, Dam Safety Study Committee. Nicole.
Thank you, Madam Chair. House Bill 2040 establishes a dam safety study committee to consider and collect information on the status of dams in the state. The bill outlines the requirements for committee members. It allows committee members to receive reimbursement of expenses and describes the duties of the committee. Finally, the bill sets a sunset date of June 30th, 2022. This is a repeat bill of last session, and it was held in Senate due to COVID. The only controversy that was brought up was by Representative Blanc on the floor. She explained that she believes we don't need a committee to tell us what we already know. According to the Department of Water Resources, in a January 21st, 2020 letter to the governor, they found that there are 16 high hazard dams that have been deemed unsafe, and fixing these dams will be very costly. And with that, I'm open to questions.
Okie doke. Well, you've done a great job. We are through with Ben and Nicole. Let's bring up Brendan and Brooke. And Brendan, if you are ready, let's start with HB 2241, Schools, Instruction, Holocaust, Genocide. We'll want to pull this one immediately from the consent calendar. Is that correct, Ms. Hernandez's bill?
Madam Chair, members, House Bill 2241, Schools, Instruction, Holocaust, Genocides, requires the State Board of Education to include in the minimum course of study that students be taught about the Holocaust and other genocides at least twice between the 7th and 12th grades. And with that, I'm available for questions.
Thank you, Brendan. Ms. Hernandez, would you like to speak to your bill?
I guess. I mean, it's the same one we did last year. I would appreciate your support once again. We promised the survivors we'd do this, so I'm looking forward to it just getting done officially across the line this time. I do want to say that the Department of Education has been working hard on trying to do what they can as far as putting the list of curriculum together and resources available for teachers. So I definitely feel great about it. It's a great bill. Please support it again. And yeah, thank you.
And Madam Chair, members, the State Board of Education did adopt this in their minimum course of study at their October 26th meeting in 2020. So this will be codifying the change that resulted from Representative Hernandez's bill last session.
Thank you, Brendan. Burritos on Ms. Hernandez. All right, HB 2301, CTEDS, letter grades exclusion. Brendan.
Madam Chair, members, House Bill 2301, CTEDS, letter grades exclusion, modifies the annual achievement profile released by the Department of Education so that career and technical education districts are not assigned letter grades. And with that, I am available for questions.
All right. Dr. Freese.
Thank you, Madam Chair. Is this because of the pandemic, or this is for perpetuity? They'll never receive letter grades.
Brendan.
Madam Chair, Dr. Freese, this would be into perpetuity. The CTEDs have been, in statute, there's a requirement that CTEDs be given A through F letter grades. However, they have never actually been given a letter grade to date. So this would just eliminate that requirement.
And just as an aside, is anybody contemplating suspending letter grades for K-12 because of the pandemic? I'm just putting that out there. Somebody can get back to me.
Madam Chair, Dr. Freese, I believe the next bill will be of interest to you.
Okay, thank you.
Thank you. So let's move on to HB 2402, schools, test results, letter classification. And I'll point out that this has already been pulled from third read consent by the bill sponsor. Brendan.
Madam Chair, members, House Bill 2402, schools, test results, letter classification, allows the State Board of Education to adjust the dates local education agencies are required to receive school and assessment data if the State Board of Education alters the statewide testing window. It prohibits the Department of Education from assigning schools and districts letter grades for the 2020-2021 school year and the 2021-2022 school year. The bill also requires ADE to collect and publish data for those two school years on academic and educational performance indicators, and directs ADE, subject to the adoption by SBE, to develop criteria to identify schools for those two school years that demonstrate below average performance. The bill also contains a retroactivity date of June 20th, 2020. And with that, I am available for questions.
Okay. I'm sorry, Dr. Freese.
Do we know why Udall is pulling it? She's got a floor amendment do we have any understanding?
Madam Chair, Dr. Freese, my understanding is that there's discussion on limiting this to a single year instead of 2 years.
Okay. All right, let's move on. HB 2403, schools, performance evaluations. Brendan.
Madam Chair and members, House Bill 2403, schools performance evaluations, allows rather than requires districts and charter schools to conduct teacher performance evaluations for the 2020-2021 school year, and specifies the absence of an evaluation that school year may not be used to enforce the dismissal or non-renewal of a teacher if they were in the lowest performance classification in school year 2019-2020. The bill also clarifies an evaluation is not necessary for a teacher to be eligible for performance pay from the Classroom Site Fund, and contains both a retroactivity date of June 20th, 2020 and an emergency clause. And with that, I am available for questions.
Representative Jermaine.
Thank you, Madam Chair. Brendan, can you repeat what bill number you're talking about? It's not on my caucus sheet.
Madam Chair, Representative Germain, it is House Bill 2403.
You got it, Jermaine?
Yeah.
Okay. All right. Okay. Let's move on to HB 2175, schools residency documentation policies. Brooke.
Madam Chair, members, House Bill 2175, Schools, Residency Documentation and Policies, requires the Arizona State Board of Education to establish policies for verifiable documentation of residency in Arizona rather than the Department of Education to adopt guidelines. And with that, I'm available for questions.
All right, seeing none. HB 2210.
I'm sorry, Madam Chair. I'm sorry.
Sorry, go ahead, Dr. Freeze.
So we're switching from ADE managing this to SBE managing this? Is that?
Madam Chair, Representative Freeze, that is correct.
Did anybody ask or say why the switch?
Madam Chair, Representative Freeze, the bill is transferring residency of documentation from ADE to SBE. So it is basically just clearing, making sure that the process is clear and defined to avoid confusion and schools being audited.
Okay.
Thank you. Rep. Fernandez.
I was wondering if Ms. Solomon could explain why she voted no, and wondering if she's going to pull it. This is a bill by Representative Dunn, and it has to do with educating children that come across the border, or that's what they're thinking happens.
Thank you, Ms. Fernandez. Ms. Solomon?
Yeah, thank you, Assistant Leader and Rep. Fernandez. Yeah, I voted no just because of some of the reasons that are being highlighted in this conversation. I just was not convinced that this needs to be moved from SBE to ADE, and we're seeing a lot of legislation this year moving functions that traditionally belong in ADE or have been handled by ADE over to SBE, and it's just, for me personally, it's just it gives the sense that we're doing this because there's a Democrat leading ADE, and SBE right now is beholden to a Republican governor. That could switch in the next election cycle, but I just don't think that they produced a compelling enough argument that we should move it over to SBE.
Thank you, Ms. Solomon. Dr. Freeze?
Just to clarify, even a child without documented immigration status gets educated, right? I mean, this is not going to keep someone from going to school.
Brooke?
Madam Chair, Representative Freeze, that is correct. The sponsor of the bill clarified that the bill is not targeting students who may live in any border towns, but it's just making sure that the process is clear and defined.
So I'm sorry, just to follow up, Madam Chair, what purpose is it to track this information? I know it's in statute already.
Brooke?
What tracking this? What I'm trying to.
Madam Chair, Dr. Freeze, there was no testimony in committee on that. We'll look into that and get you an answer.
Thank you, Brendan. Thank you, Brooke. And then Ms. Fernandez, last word, please. Oh, and then I see Ms. Teran popped up. So Ms. Fernandez, Ms. Teran, and then let's move on.
I do appreciate that Brendan's going to follow up on this. It is about kids coming across the border and children being hounded at their houses in our local area along the border to see if they really live there, if they're there late at night, if they're there early in the morning, and if they're not, there's an issue of their residency.
Thank you, ma'am.
Thank you, Assistant Leader. Thank you, Ms. Fernandez. That's a great comment. I'll echo that. And then also the AEA is against this bill.
Point taken.
Is someone going to pull it?
Who wants to pull it? Anyone? Dr. Freeze, I see Dr. Freeze first. So Dr. Freeze is, Ms. Pollock, you're pulling it? All right, so let's give it to Ms. Pollock, ranking member. Okie doke. Let's move on to HB 2210, school functions, food, beverages. Brooke.
Madam Chair, members, House Bill 2210, school functions, food and beverages permits, subject to policies adopted by the Department of Education, a school district governing board to provide food and beverages both at school district events, including official school functions and trainings, and through a cafe that is open to the public. With that, I'm available to answer any questions.
Okay, Brooke, let's move on to HB 2259, Common School Districts Unification Budget.
Madam Chair, Representative Hernandez had his hand up for the last bill.
Oh, I'm sorry. Who did?
I did. Sorry.
I'm sorry.
Go
ahead.
I thought there would be more questions on the bill, and there's an amendment to remove cafes. So I just wanted to raise it. There will be an amendment on the bill on the floor to remove the cafes.
All right. Thank you, Mr. Hernandez. And then let's go back to Brooke on HB 2259.
Thank you, Madam Chair. Madam Chair, members, by way of background, in 2006, voters approved the unification of Natterburg Unified School District. However, the district had been unable to build a high school since unification. Because of this, Natterburg has been tuitioning their high school students to surrounding high schools and have been calculating their budget and equalization assistance as a common school district until they can build a high school. House Bill 2259, Common School Districts Unification and Budget, allows the school district to continue the practice of tuitioning their students and calculating their budget and equalization assistance until a high school is approved or within 10 years. The bill is retroactive to July 1st, 2020 and contains an emergency clause. The 5-line Udall amendment changes the date that allows a common school district to continue calculating its budget and equalization assistance to 15 years after the election or until high school is built, whichever occurs first. And with that, I'm available for questions.
Okay. HB 2268, schools, total compensation statements. Brooke.
Madam Chair, members, House Bill 2268, schools and total compensation statements, requires a charter school governing body and a school district governing board to provide each employee a total compensation statement broken down by category every fiscal year. And with that, I'm happy to answer questions.
Okay. Thank you, Brooke. Thank you, Brendan. Let's move on to Jane and Nicole. Folks, let me just clarify, since I'm coughing, I have dust in my throat. I'm not sick. All right. Jane, let's begin with HB 2130, intensive probation requirements modification.
Yes, Madam Chair and members, good morning. HB 2130 provides that the definition of intensive probation includes individualized treatment for a person who's deemed appropriate for the program and removes several conditions for granting intensive probation. It allows the court or a probation officer to modify the level of intensive probation supervision at any time, and it removes language providing for a court to issue an arrest warrant for a person who commits a violation of a condition of probation, while still allowing the court to revoke probation if a violation poses a serious threat or danger to the community. And with that, I'm available for questions.
All right, HB 2428, victims' privacy, criminal case information. Jane.
Madam Chair and members, House Bill 2428 requires a victim's identifying and locating information to be redacted from records disclosed to the defendant's attorney or the attorney's staff, in addition to the defendant themselves. And with that, I'm available for questions.
HB 2012, unauthorized racing meetings, penalties, racketeering. Jane.
House Bill 2012 makes it a Class 6 felony to hold or conduct a horse racing meeting without a permit and allows the offense to be prosecuted as racketeering if it's committed for financial gain. And with that, I'm available for questions.
Mr. Rodriguez.
Members, this is a solution in search of a problem. think the testimony from the witness from the Attorney General's office made it pretty clear that they are just looking for another justification to establish probable cause to start these investigations of people they suspect of criminal activity. But holding an unlicensed race is already punishable under the current law. From what we can tell, they just want another offense. This is literally just creating another offense when they have other ways of doing it. And the answers we got from the witness from the Attorney General's office were not satisfactory. So I'm going to ask to have this pulled off the consent calendar.
Okay, so we'll pull that from consent for Mr. Rodriguez, and then I see Freeze, then Shaw. Dr. Freeze.
Thank you, Madam Chair. Does this have anything to do with the battle we had a few years ago between Prescott and Turf Paradise? Is that addressing that at all? This, or is unrelated?
That's a very good question, but it doesn't. This is the Attorney General's office is frustrated because they had 3 cases they tried to put together and they lost 2 of the 3. So this is literally just a prosecutor's office saying we got beat under the current rules, change the rules so it'll make it easier for us to get a conviction, but already punishable under other statutes.
Thank you. Shaw?
Thank you, Madam Chair. I don't understand. What is a racing meeting? Is it just like a bunch of people getting together talking about racing, or is it the actual racing?
It's the way it was presented to us in committee. It's the actual racing. It's just an informal group of people who get together informally and they race horses. There'll be vendors there. There'll be other interested people, spectators, vendors, and they tried to blow it up into this huge possible cartel-related activity. But really, what it just came down to was that it's people who they can surveil or investigate under other laws. And they're just not successful at it, so they want another statute.
So sorry, so Madam Chair, so it's not a bunch of people sitting in a room discussing racing. Like it gives the impression that they're trying to find. I mean, because especially if they're talking about racketeering rather than the actual race of horses.
Madam Chair, Dr. Shaw, I can clarify. So there's a statutory definition of race meeting. A race meeting is an occasion when a series of horses or greyhound races are held at the same time and place, often over a period of several days.
Okay, all right, thank you.
All right. Okay, moving on. HB 2027, leaving accident scene private property. Jane.
Madam Chair and members, House Bill 2027 increases the misdemeanor penalties for leaving the scene of an accident and failing to inform the property owner of the accident, and clarifies that these penalties apply to accidents that occur on public or private property. And with that, I'm available for questions.
All right, HB 2178, theft by extortion defense. Jane.
Madam Chair and members, House Bill 2178 amends the legal defense to theft by extortion and clarifies the criminal penalties. Specifically, it provides that it is a defense to prosecution for theft by extortion involving the accusation of a crime, the exposure of a secret, the taking or withholding of action as a public servant, that the property or services obtained or sought to be obtained by threat of accusation, exposure, or lawsuit was a reasonable claim. And it clarifies the existing criminal penalties. And with that, I'm available for questions.
Okay. HCR 2002, Supreme Court, maintain 9 members. Jane.
Madam Chair and members, House Concurrent Resolution 2002 is a concurrent resolution calling to amend the United States Constitution to set the number of United States Supreme Court justices at 9. And with that, I'm available for questions.
Representative Rodriguez.
Members, this is a ideologically driven bill by Mr. Hoffman. 12 current members of the legislature on the other side voted in support of Doug Ducey expanding our own Supreme Court. The explanation they gave in the committee for this was basically, it was just a contrivance. This is entirely because Mr. Hoffman's trying to make a point. I think this is a really excellent opportunity for us to point out on the floor. A, this bill is it's a waste of time, given the other more important issues we have to address. And B, there couldn't be a more clear example of Republican hypocrisy when it comes to issues like this. It's good for the goose, but again, only the goose.
So I'm hearing you're pulling it from consent?
Correct.
All right, thank you. Dr. Freeze?
Thank you, Madam Chair. I did vote against Ducey's bill to expand the court, but I voted against it because I wanted to do the expansion in his first term, one judge, and then the next governor, the other judge. They rejected that, so I did vote no. I don't support this. Congress now determines the number of Supreme Court justices. In fact, in the history of this country, there's been anywhere from 6 to 10 Supreme Court justices. So it has moved around, and it should be able to move around as Congress sees fit.
Thank you. Okay, let's move on. HB 2260, Arizona Criminal Justice Commission membership. Nicole, you're up.
Madam Chair, members, HB 2260, Arizona Criminal Justice Commission membership, adds a public defender and a victim advocate to the Arizona Criminal Justice Commission. The bill changes the number of members of the Arizona Criminal Justice Commission appointed by the governor to 16. Includes that of the 16, there can only be up to 8 members belonging to the same political party. And lastly, it adds that there must be 1 public defender and 1 victim advocate within the members of the Criminal Justice Commission. There are no amendments for this bill, and with that, I'd be happy to answer any questions.
Ms. Solomon.
Thank you, Madam Chair. Madam Chair, Nicole, is it defined in statute who qualifies as a victim's advocate?
Nicole.
Madam Chair, Representative Solomon, let me check here. No, it does not. All it says is that under current statute, 14 members must be appointed, and up to 7 can be from the same political party.
Okay, Madam Chair. So maybe this is a question to the members on the committee. How are we ensuring, or how are we defining victims advocate? And just intention behind my question is just making sure that it's an actual victims advocate and not just someone random.
Mr. Rodriguez?
Well, I don't believe that there is I could be wrong, but a victim, for court purposes, a victim advocate is anybody that the victim designates to advocate on their behalf. Generally, it's an attorney. So, or somebody from an associated organization. Most county attorneys' offices have victim advocates. They are trained professionals who handle those duties. So that's the context of what a trained advocate is. As far as how it will be applied in this case or in this bill, that's a very good question, but I don't think that they would go that far outside of the arena, given that they have people who literally are called trained victim advocates. But that's an interesting point that you raised.
Mr. Rodriguez, you had your hand up before that question. Was there anything else you wanted to add before I go to Mr. Main?
Yeah, I've talked to Mr. Blackman about some other amendments on this, changing the phrase public defender to head of an indigent defense agency. So we have that person is on the same level as the sheriffs and the county attorneys who are on part of it. I've talked to him about maybe adjusting the maximum number of people who can be from one party. That would force people on who were independents. And so I'm going to go ahead and protest this one as well, get it off the consent calendar so I can circle back and see where we're at.
Thank you, Mr. Rodriguez. We have Mr. Main, and then we have Ms. Tron. Mr. Main.
So to Ms. Solomon's point, victim advocate is defined in rule with the ACJC under their victim compensation fund rules. And the AG's office also has a rule definition of victim advocate.
Madam Chair, to that point, if I may. Thank you, Madam Chair. So should we look at those definitions and maybe, Rep. Rodriguez, since you're working with the chair on an amendment already, should we just be a little more specific?
I don't see a downside to doing that. I'll make a note of that. Thank you.
Ms. Tron.
Thank you, Madam Chair. Just to, we did talk in committee about the Indigenous Defense Agency, like Mr. Rodriguez said, as well as a nonprofit juvenile justice organization and a psychiatrist to be added to the membership. And yeah, I think that the hopefully the bill sponsor is open to that as well. But Mr. Rodriguez will lead that conversation.
Mr. Main, last word.
Yeah, we also had a recommendation from the Missing and Murdered Study Committee, and there is a bill floating around to add a tribal member to the ACJC as well.
All right, thank you. Okay, so we're nearly halfway through. Latino Caucus starts in 50 minutes. Let's see what we can get done here. HB 2066, arrest procedures, magistrates. Nicole.
Thank you, Madam Chair, members. HB 2066, Arrest Procedures Magistrates, allows an arrested person to be taken to the nearest magistrate in the county where the arrest was made, or to the nearest magistrate in the county where the offense was committed. The bill provides that a person who is arrested without a warrant may be taken to the nearest magistrate in the county of arrest, even if the offense was committed in another county. A person who is arrested without a warrant by a private person be taken to the nearest magistrate in the county, even if the offense was committed in another county. Adds that a person who is arrested with a warrant be taken to the nearest magistrate in the county, even if the offense was committed in another county. And lastly, it specifies that a person who is arrested with a warrant, which includes a bond amount in a different county than where the offense was committed, be taken to the nearest magistrate in the county where the arrest was made. And the person arrested is expected to appear in court if let out on bail at the time of the arrest. There are no amendments for this bill, and with that, I'd be happy to answer any questions.
Okay. HB 2073, records confidentiality, eligible individuals. Nicole.
Thank you, Madam Chair, members. HB 2073, records confidentiality, eligible individuals, adds hearing officers and members of the commission on appellate court appointments to the list of persons whose personal information is protected from being made available on the internet. There are no amendments to this bill, and with that, I'd be happy to answer any questions.
Okay, thank you, Jane and Nicole. Magali and Tuba, you're up. Oh, wait, did I miss one?
2075.
Yes, I did. I apologize. My mistake. All right, Nicole, you've got one more. HB 2075, sentencing, judgment of guilt, fingerprints.
Thank you, Madam Chair, members. HB 2075, sentencing, judgment of guilt, fingerprints, modifies the procedure for affixing a criminal defendant's fingerprint to the court documents at sentencing. The bill provides that at the time of sentencing, a defendant for a felony or other criminal offenses requiring fingerprinting, the court shall require the defendant's fingerprint be permanently affixed to the sentencing order or judgment of guilt document, or that the defendant's two fingerprint biometric-based identifier be obtained and recorded in the court's case files. And it strikes the requirement that the court permanently affix the defendant's fingerprints at the time of sentencing and in open court. There are no amendments for this bill, and with that, I'd be happy to answer any questions.
Okay. All right, thank you. Jane, would you work with Nicole in IT and see if we can do anything about her microphone for the future?
Yes, definitely. Thank you, Madam Chair.
You did a great job, Nicole. It's just, there's some technical issues happening. Magali, Tuba, it is now your turn. We're going to start with HB 2297, military leaves of absence, duration. Magali.
Madam Chair and members, by way of background, current statute allows members of the National Guard or Armed Forces Reserves to a period of leave not to exceed 30 days for 2 consecutive years. House Bill 2297, military leaves of absence duration, recalculates military leave period for members of the Arizona National Guards or the Reserves as follows. A full-time officer or employee who works 2,080 hours annually is entitled to up to 120 hours of military leave annually. An officer or employee who is regularly scheduled to work more than 2,080 hours is also entitled to 15 days of military leave to total not more than 100 military leave each fiscal year based on the total number of hours in the individual's regularly scheduled biweekly hours. And with that, I'm available for any questions.
Dr. Freeze.
Magali, officer, employee, does that encompass also enlisted people?
Magali.
I missed that.
Madam Chair, Dr. Freeze, yes.
Thank you.
Okay. HB 2294, yielding to emergency vehicles penalties. Tuba.
Madam Chair, members, House Bill 2294, yielding to emergency vehicles penalties, establishes penalties for individuals who fail to proceed with due caution when approaching a vehicle displaying flashing lights or warning lights. The 6-line Payne Amendment, dated at January 21st, 2021 at 9:38 a.m., mandates traffic schools and drivers education programs approved by ADOT to include more move over law information in ADOT's examination, information, or education material. The amendment also requires a person that violates this section to be liable for any injury and damage to property. With that, I'm available for questions.
All right, Tuba, HCR 2003, law enforcement first responders honoring. Tuba.
Madam Chair, members, House Concurrent Resolution 2003, law enforcement first responders honoring, expresses gratitude to all law enforcement and first responders in the state of Arizona. With that, I'm available for questions.
Okay, HR 2002, Simile Massacre, Assyrian Martyrs Day. Tuba.
Madam Chair, members, House Resolution 2002, Simile Massacre, Assyrian Martyrs Day, honors the victims of the Simile Assyrian Massacre of 1933. With that, I'm available for questions.
HB 2007, speed limits, roadway turnoff. Tuba.
Madam Chair, members, House Bill 2006, speed limits, roadway turnoff, modifies the definition of vehicle to include human-powered and electric bicycles and scooters, personal mobile cargo carrying devices, regarding to when a vehicle is driving at such a slow speed that it impedes or blocks the normal and reasonable movement of traffic. The 12-line Carroll Amendment, dated at January 21st, 2021 at 1:29 p.m., adds the definition of turnout, and the amendment also expands the definition of vehicle in point 1 as bill is introduced to include personal delivery devices. With that, I'm available for questions.
Mr. Andrade, you just unmuted. You're the no vote on this. I assume you have something to say?
Yes, Madam Chair, I'm actually supporting it, so I will be voting for it and in support of it on the floor.
Thank you, sir. Dr. Freeze?
Madam Chair, I guess I'm just a little bit confused. Are we redefining a vehicle? The language says something about means a device in or by which a person or property is or may be transported on a highway, includes all the following: electric bikes, electric miniature scooters, electric stand-up scooters. By saying that these things need to have speed limits, are we allowing them now on highways? I'm confused about, these things should not be on highways.
Tuba?
Madam Chair, Representative Freese, this bill is saying that if these vehicles are on the highway, they are supposed to be turning off the highway. So it is my understanding that if they are on the highway, then they should be turning out to not impede traffic.
Okay, so we're basically saying they should not be on the highway, and if they are, they need to get off immediately. Okay, got it.
Okay. HB 2083, safety features, autonomous vehicles prohibitions. Tuba.
Madam Chair, member.
I'm sorry, Tuba, could you hold for 1 second, please? I'm sorry, Jermaine, did you have something on the last one?
Yes, to Dr. Freese's point, there is separate statute that precludes those man-powered vehicles from being on urban freeways.
All right, thank you, ma'am. All right, Tuba, let's continue then with 2083.
Madam Chair, members, House Bill 2083, Safety Features, Autonomous Vehicles Prohibitions, prohibits a person from installing or using a device that would interfere with or disable a safety feature of a vehicle that is designed to ensure that a human driver is alert and attentive while the driving automation features are engaged. And it clarifies that this section does not apply to either an entity that is testing automated driving systems pursuant to executive orders or other programs that authorize, and entities such as a motor vehicle manufacturer, service center, motor vehicle dealer, motor carrier, component manufacturer, or automated vehicle technology developer that is making motor vehicle modifications that are consistent with the manufacturer's or component manufacturer's safety standards, whether physically or remotely. The 11-line Carroll Amendment, dated at January 26, 2021 at 5:09 p.m., clarifies that a person may not knowingly and intentionally install or use a device that would interfere with or disable a safety feature of a vehicle that is designed to ensure that a human driver is alert and attentive while the driving automation features are engaged. It adds the motor vehicle diagnostic service providers, independent repair facilities, auto glass repairs, replacement, and recalibration service providers to the entities whom this section does not apply to. And the amendment also modifies the definition of defeat device and strikes the definition of install or use a defeat device. With that, I'm available for questions.
Okay, HB 2134, commercial driver's license third parties. Tuba.
Madam Chair, members, House Bill 2134, commercial driver licenses third parties, authorizes third-party driver license providers to perform administrative and testing functions for the issuance and renewal of commercial driver licenses as authorized by the director. It also contains an emergency clause. The 2-line Carroll Amendment, dated at January 22nd, 2021 at 8:30 a.m., adds that the authorization of third-party driver license providers to perform administrative and testing functions for the issuance and renewal of commercial driver licenses must also be pursuant to federal law. With that, I'm available for questions.
HB 2140, license plates designs. Tuba.
Madam Chair, members, House Bill 2140, license plate designs, establishes specific license plate font and color requirements. With that, I'm available for questions.
HB 2143, ADOT revisions. Tuba.
Madam Chair, members, House Bill 2143 ADOT revisions. With regards to scrap metal dealers, the bill clarifies that an automotive recycler must take a picture of the owner instead of the seller and obtain a signed statement by the owner, not the seller of the vehicle. Instructs registered scrap metal dealers or licensed automotive recyclers who discover that a vehicle is stolen to report the findings to a law enforcement agency instead of ADOT. Stipulates that the electronic system retain records of searches as specified in its record retention schedule. With regards to towing companies, the bill requires that towing companies register with the state's procurement office in order to qualify for being entitled to receive 20% of the fee collected by the department as a partial reimbursement for towing an abandoned vehicle. Point 7, the bill adds being convicted of sex trafficking, trafficking for persons for forced labor or services, or child sex trafficking as grounds for permanent disqualification for a commercial license. The bill also mandates any person who sells a salvage vehicle or restored salvage clearly and conspicuously disclose to the buyer in writing or by electronic means before completion of the sale that the vehicle has a salvage certificate of title. With that, I'm available for questions.
HB 2144, ADOT revisions, aircraft staggered registration. Tuba.
Madam Chair, members, House Bill 2144, ADOT revisions, aircraft staggered registration, exempts motor fuel that originates outside the state, is moving in interstate or foreign commerce, and is not destined to a point in the state from motor fuel taxes. Adds conditions that excuse the Transportation Board from conducting an annual financial audit of the fund. With regards to aircraft registration, the bill exempts balloons from having to register with the Department for Aircraft Registration. It mandates the director to establish a system of staggered aircraft registration and outlines the reasonable discretion the director should exercise in order to make sure the staggered system is efficient. The bill also adopts fleet registration requirements that consist of an application containing information necessary for qualification as a fleet registrant and a list of all aircraft to be included in the fleet. With that, I'm available for questions.
Okay, HB 2159, school bus drivers license requirements. Tuba.
Madam Chair, members, House Bill 2159, school bus drivers license requirements, adds possession of a commercial driver license to the minimum standards for the certification of school bus drivers. With that, I'm available for questions.
HB 2173, commercial driver's license renewal time. Tuba.
Thank you, Madam Chair, members. House Bill 2173, commercial driver licenses, renewal time, increases the commercial driver license renewal period from 5 years to 8. With that, I'm available for questions.
Okay. All right. Thank you, Magali and Tuba. Matt and Piper, you're up. We're going to start with HB 2120 timeshares, public records, public reports, purchase contracts. Matt.
Thank you, Madam Chair and members. House Bill 2120 updates the time frame for canceling a timeshare to reflect a 10-day cooling off period rather than a 7-day cooling off period, and would require information regarding the cooling off period to be contained prominently right above the purchaser's signature line before they sign to buy a timeshare. With that, I'm available for questions.
HB 2160, Occupational Safety Advisory Committee Enforcement. Matt.
Thank you, Madam Chair, members. House Bill 2160 updates requirements for sorry, I'm a bit flustered here. House Bill 2160 creates stricter requirements for employer responses to unemployment claims, removes occupational safety committee's input into the governor's nominations to serve on the review board. With that, I'm available for any questions.
Okay. HB 21. Oh, I'm sorry, Ms. Fernandez, I missed you. Please.
I was wondering about the no vote. I'm on that committee and I didn't remember that.
Right. So Mr. Espinosa was a no vote. Mr. Espinosa? We'll have to ask him separately, ma'am. Ms. Powers-Hanley?
Yeah, okay.
Yes, thank you, Assistant Leader Longden. I had a clarifying question for Matt, because I know that when we had the briefing, we discussed this idea of the OSHA, the Arizona OSHA board, no longer being able to suggest members for the board. Now, the lobbyist said that that part of this bill was already passed, and it's my understanding it's that part of the bill that the unions were against, but it seemed like it was already a moot point, and which is why we voted yes. Am I correct in this, Matt?
Matt?
Thank you, Madam Chair, Ms. Powers-Hanley. That is, you're correct as to what the lobbyist said. And I'm not aware of where it was passed, but I can check into it and get back to you.
Okay, thank you. That might be why Espinosa voted no, because there was a little bit of confusion that some unions were against this, but then it seemed like the part they were against was already a moot point, unfortunately.
Thank you, Ms. Powers-Hanley. Okay, Freeze?
Matt, can this conditional enactment clause, any indication if it's likely that the feds would approve this change?
Madam Chair, Dr. Freeze, the conditional enactment clause does require federal approval from federal OSHA. There's no reason to believe that the feds would not approve this change. However, because of the way that they have to approve it, there's a conditional enactment clause in there to be safe.
Okay. All right. Moving on. HB 2172, Wireless Providers Authority, Applicability. Matt.
Thank you, Madam Chair. Members, House Bill 2172 would remove an exemption from statute which restricted the abilities of municipalities near the U.S.-Mexico border to attract wireless providers. With that, I'm available for questions.
HB 2139, ASRS Self-Insurance Program. Matt.
Thank you, Madam Chair. Members, House Bill 2139 would clarifies and establishes the procedures for through which ASRS may fund its self-insurance program for retirees' health benefits before they reach the age of 65 and qualify for Medicare. With that, I'm available for questions.
Freeze?
Yeah, I don't know if the committee discussed this, but would this be a good place to add teachers into AS? No, wait, I'm thinking about medical coverage for teachers. Is that something? That's retirement. Okay, I'm misspoken.
No worries. Ms. Fernandez.
No problem.
Okay, okay, thank you. HB 2313, Information Technology Authorization, State Treasurer. Matt.
Thank you, Madam Chair. Members, House Bill 2313 authorizes the Arizona State Treasurer to develop and run her own IT system and transition away from the system run by ADOA. With that, I'm available for questions.
HB 20, we have questions. All right, so I saw Epstein, then Powers Handley. Ms. Epstein?
Was there any reason given for this, and who would pay for it and so on? Was there justification, testimony?
Matt?
Thank you, Madam Chair, Representative Epstein. The State Treasurer's Office said that they believe that it's a conflict of interest for the State Treasurer who runs the audits of, who audits the financial systems of the state to use the same IT system that the ADOA uses because they audit ADOA. And so this would add an additional layer of independence between the Treasurer's Office and the ADOA. As for the expense, Ms. Epstein, I'm not sure, but I imagine it would be paid for out of the Treasurer's own budget.
Thank you, Matt. Ms. Powers Handley.
Thank you, Representative Longden. Epstein pretty much had my questions, and I'm also concerned because I've seen the state, do different databases, and then all of a sudden you have databases that don't talk to each other. So this raised some red flags to me also. And I have a big question of why.
Thank you. Did you mute? Okay, you muted, and I didn't know if you were quite finished. Okay. HB 20, oh, there we go. Freeze.
I'd like to go back to 2139. The ASRS program, I'm trying to remember, do retired teachers get health benefits through ASRS?
Matt?
Thank you, Madam Chair. Dr. Freeze, I am not sure about that. I can get back to you, but I know of no reason why they would not be covered under ASRS.
All right, so we've got a bunch of hands that popped up. I think it was Fernandez, then Jermaine. Rep. Fernandez?
Yeah, I'm running a bill for a study committee on health insurance for teachers through the state. That's a really good question that Dr. Freeze is asking, and he texted that maybe we should add an amendment to that. Matt, I hope you can look into that and see if that's doable. That's a great idea.
Thank you, Matt. Thank you, ma'am. All right, I see Jermaine, then Pollock. Jermaine.
The answer to Dr. Freeze's question is yes, retired teachers get health insurance through the ASRS.
Perfect.
And this is just a gap program for those who retire before they are age 65 and qualify for Medicare.
Thank you. Excellent. Thank you.
Thank you, Ms. Jermaine. Rep. Pollock.
Thank you, Madam Chair. And just to piggyback on what Rep. Jermaine said, if somebody starts teaching when they're 22, they can retire at 52. So there is a gap of time that this covers.
Thank you, ma'am. Okay, let's move back to HB 2380, Mormon Migration Monument, Government Mall. Matt.
Thank you, Madam Chair. Members, House Bill 2380 authorizes the construction and the maintenance of a monument honoring Mormon pioneers on the Capitol Mall. It would not receive state funding and would be independently funded. With that, I'm available for questions.
Ms. Solomon, anything here?
It's kind of one of those vote your conscience. I personally, we see these bills every year to erect a new monument on the mall. There doesn't seem to actually be like a comprehensive plan for what we're putting there. It seems more like whatever group can raise the money and persuade enough legislators to allow them to be there, they should be there. Also, I know that this is tied to Lee's Ferry, which I personally have some concerns about the history of that as it pertains to violence towards our Indigenous communities during that era. So, it's for both reasons I voted no, but yeah, and then this is a repeat bill from years previously. I think this has gone through the legislature and then for whatever reason didn't make it all the way through. So that's just some background of where I was coming from on that.
Thank you, Ms. Solomon. Okay, HB 2161, Tourism Marketing Authorities. Piper, before I give that to you, I'm going to point out that Ms. Bullock has already pulled this bill from consent. Piper?
Thank you, Madam Chair, members. House Bill 2161, Tourism Marketing Authorities, establishes the structure of a tourism marketing authority, including the formation process, its powers and duties, taxing policies, and termination process. The bill also includes an emergency clause. And with that, I'm happy to answer any questions.
Ms. Powers Handling.
Yes, thank you, Representative Long. Is this on consent?
It's been pulled by Ms. Bullock already.
Okay. So I just wanted to say that this bill is another bill for quasi-governmental taxing districts. It would allow an unknown number of marketing authorities across the state. Any municipality or county can create them. And so besides looking tone deaf for an emergency bill for tourism during a pandemic, I think that there are serious questions about more bureaucracy, charging tax dollars, and then having the taxpayers not really have any say in how those tax dollars are spent. So this has got a lot of issues, in my opinion.
Yes, ma'am. So I see you, Mr. Mesa. Give me 1 second because Dr. Freeze is ahead of you. Rhonda, would you just double check and make sure that was pulled from consent, that I got the right bill? So I'm going to go Freeze. Mesa, was yours to that point? All right. If not, no. I'm going to go Freeze, Mesa, and then D'Alessandro. Freeze.
Thank you, Madam Chair. Does this bill require a 108? We are raising revenues. Is it because it's not state revenues? Is it?
Piper?
This bill does not require 108. So
can you help me understand why?
Piper?
It seems like the money that is being raised is entirely the Tourism Marketing Authority's own money being raised, so it doesn't actually use state funds at all.
Okay.
Could I answer the question?
Please.
Yeah. So yes, Piper's right. The 67% of the lodging institutions in the marketing authority have to agree to establish it, and then they agree to charge a bed tax or an additional bed tax. That money is then funneled up to, from an unknown number of marketing authorities, funneled to the DOR. DOR processes it, sends it back to the cities, and then it goes to the tourism authority. And so it's that sort of thing. The sponsor says it's not going to cost any money, but obviously it adds a lot of processes to DOR. So yes, basically the hotels say, yes, we're going to charge this tax, and then they get the money back for tourism.
Thank you. All right, Mesa, then D'Alessandro, then Epstein. Mr.
Sure.
Mesa.
I don't think we would have ever seen this bill come forward if it hadn't been for COVID. So this is a response to COVID. It's a rapid response. I guess there's 30 other states that have implemented this type of program within their states. Secondly, my first generation of my legislative district, I have new immigrants from around the world work in the hotel industry arena, and they're impacted by this. So it would benefit them if they could get back to work. And I've had many calls on this within my legislative district, especially monolingual people saying that they really need help so they can get back to work. So I'm in support of this bill.
Thank you, Mr. Mesa. Ms. D'Alessandro, then Ms. Epstein, and then Dr. Freeze.
Thank you, Representative. I would like to know where the origin of this bill came from, because I represent Ola Santa Cruz County, and I have been working on similar initiatives with hoteliers and bed and breakfast places. So the border and tourism has been one of my passions for all 9 years. So what was the genesis of the bill? Thank you.
Piper, can you answer that?
Madam Chair, Representative, according to my analyst, it came from the hotel organization, but I currently don't have the details, but I can get back to you on exactly what that was.
All right, Ms. Epstein, and then Rodriguez, I see your hand up. I think I've been missing you. All right, so Epstein, Rodriguez, then Freeze.
First, we need to clarify, is this House Bill 2161?
Yes, it is.
Thank you. It sounded like it, but it didn't make sense on my list. So I just want to point out also that we got an email indicating that the Free Enterprise Club, not my favorite organization, but nonetheless, has pointed out that he has serious constitutionality problems. The bottom line is that if you create a new political subdivision to tax people, then that taxing district is the one that must be the decider. But this bill gives that decision-making authority to the Chamber of Commerce, a private institution. And therefore, the Free Enterprise Club says this is in violation of the Arizona Constitution, the tax clause of the Arizona Constitution. So food for thought.
All right. Rodriguez, then Freeze. And Mr. Rodriguez, I missed you because your camera wasn't on, so I couldn't see who had raised that hand. So you're up.
Thank you. Piper, I have a question for you. What's the length of, does the bill put a duration on the operation of this type of district? Or we just create it and then it just runs as long as they want to do it?
Piper?
Yes, Madam Chair, Representative, this bill has a ending date of 10 years after its origin unless it is re-upped, like re-voted for. And it can be ended sooner if voted with a majority vote by the members of the authority.
And Madam Chair, Piper, the money goes into the Tourism Authority's general budget, is that correct?
I believe so, yes.
Right. And then just one comment, Madam Chair. Members, yesterday we heard a bill in Land and Agriculture that wanted to appropriate originally $9 million to the Arizona Dude Ranch Association. And then they felt the heat coming on that, so they knocked it down to $900,000. But it's ostensibly going to go to the Tourism Authority to help them promote dude ranches. So I think one hand clearly is not talking to the other. Mr. Cook expressed his concern that he thought there would be double dipping on this as well, the 900,000 appropriation on top of what they're trying to do here. So I just wanted to bring that all to your attention, but I didn't realize that there was the objection that Ms. Epstein raised. That probably is unconstitutional. The legislature cannot delegate one of its plenary powers to either another branch or to a private party. So I think Ms. Epstein's point is well taken.
Thank you, Mr. Rodriguez. We're gonna go Freeze, and then we're gonna give Ms. Powers-Handley the last word. We're gonna keep moving. Dr. Freeze.
Thank you, Madam Chair. Just a quick question. Is this considered a service? We just passed that constitutional amendment that we can't tax services. Just to put it out there, I don't know if providing hotel rooms is considered a service. And also, is there a mechanism? I mean, I get Mr. Mesa's point about, responding to the COVID emergency and trying to help keep those jobs going, but is there a mechanism to turn this tax rate back down? I guess Brooke just said it was for, the board could do it. Does anybody know if this is a service or not?
Piper, and then I think Jermaine had a to that point. Is that a to that point, Jermaine? Okay.
Madam Chair, Representative, I am currently unsure of its status, but I can get back to you with that information.
I believe.
And as for the second question, I'm also a little bit unsure. If you could repeat that second question, or if that was just a clarification.
No, what mechanism is it to decrease the tax rate?
I don't believe that in this current bill that there is a mechanism to decrease it.
Let's give Jermaine her to that point, and then Powers-Handley, we're going to give you the last word on this.
To that point, for Rhonda, can we request that the rules attorney look into the constitutionality of delegating that taxing authority?
Madam Chair, members, it was reviewed in rules and not found to have any constitutional problems, but I will circle back with Tim and Crystal.
Thank you.
Thank you, Rhonda. Ms. Powers-Handley, close this out for us, please.
Yes, I wanted to address Dr. Freeze's question and Mr. Rodriguez's question. It's the members of the lodging, the lodging establishments who are members of the authority set whatever the bad tax is, and they can decide to raise it or lower it. Right now, it has a $5 per bed cap on it. And Rodriguez's authority is whether the money goes back to the state marketing authority. No, it goes back to the local municipalities and then to their tourism bureaus. And so it's going to go down to local level. I asked how much money they thought they were going to make with this. And the lobbyist said the only city that's actually tried to figure this out was Mesa, and they thought that they'd get $5 million out of this. So that's quite a bit of bed tax.
Okay, thank you, ma'am. Let's move on to HB 2243, Occupational Professional Licensure Notice. Piper.
Thank you, Madam Chair, members. House Bill 2243, Occupational and Professional Licensure Notice, requires a regulating entity to print a notice on their websites and all license and certificate applications. The notice states that a person will be granted a license if the person has been licensed in another state for at least 12 months in the same discipline and practice level as the one applied for. And with that, I am happy to answer any questions.
Okay, Freeze.
For some reason, they aren't applying this to Title 32, Chapter 24 and 26, which are private investigators and security guards. I'm wondering why.
Piper?
I currently do not have that information, but yet again, I can get it back to you.
Jermaine?
Thank you so much, Madam Chair. Piper, does this apply to professional licenses such as engineering, medical licenses, law licenses? Would we be devaluing the value of an Arizona license?
Piper?
I believe that it possibly, I think it does apply to those, but I just know that this bill is a follow-up to a 2019 bill on universal licensing, and it's trying to conform to like national standards and allow things to transfer across state lines. And I think that is the intent of the bill.
Ms. Powers-Handley has it to that point, and then I see Dr. Shaw.
Yes, this is a bill that we had last year in Regulatory Affairs. The reason that I voted no on this is I see this as unnecessary bureaucracy to require, and it's not free, right? The sponsor says, oh, this is not going to cost any money. Well, somebody's going to have to put that notice prominently on every single piece of communication. And yes, I do think it dumbs down our licenses. It is a follow-up to the previous bill, as Piper said, in that we passed this, that even with 1 year of experience, we'll take whatever the license you have, you know. And so this just creates unnecessary work as far as I'm concerned. And it's an unnecessary bill, in my opinion.
I supported this bill last year. I was against the universal licensing 2 years ago, but it passed, and there were some others in support of it. I understand there was even some division on our side. I think Senator Sinema was even in favor. But anyway, I was strongly against it for a lot of reasons. But it passed, and then the following year, what to do was just communicate the fact that this was out there. So they wanted to put it on every single thing. We heard this in RA, as Representative Powers-Handley said. And I offered a friendly amendment that it be the initial mailing, or it really took it down. So the friendly amendment was accepted. I thought this bill had made it through. Apparently it didn't. And so I eventually ended up supporting this. It just communicates the law. I didn't have a huge problem with it because they accepted my amendment. So there's the background.
Thank you, Sean. Okay, we have 25 bills to go, folks. Let's see, HB 2267, professional licensure fees, waiver reduction. Piper.
Thank you, Madam Chair, members. House Bill 2267, professional licensure fees, waiver reduction, requires a regulatory board or agency to reduce or waive fees when its projected budget surplus exceeds 50% of the appropriations from the same year. And with that, I'm happy to answer any questions.
Okay, HCR 2014, United States-Taiwan Partnership. Piper?
Thank you, Madam Chair, members. HCR 2014, United States-Taiwan Partnership supports a trade agreement with Taiwan as well as Taiwan's participation in international organizations. And with that, I'm happy to answer any questions.
Okay. HB 2051, procurement information disclosure bidders. Piper.
Thank you, Madam Chair, members. House Bill 2051, Procurement Information Disclosure Bidders, provides a question and answer period for bidders outside of the procurement process. And with that, I'm happy to answer any questions.
HB 2177, State Personnel Board hearings, Piper.
Thank you. Madam Chair, members, House Bill 2177, State Personnel Board hearings, changes the complaint filing timeline from a public employee against their employer for the State Personnel Board from 10 calendar days to working days, and increases the maximum time the State Personnel Board will take to address an appeal regarding dismissal, suspension, or demotion to 60 days, and requires the employee and employing agency to be notified before a hearing or board meeting. And with that, I'm happy to answer any questions.
HB 2312, Lease Cost Review Board repeal, Piper.
Thank you. Madam Chair, members, House Bill 2312, Lease Cost Review Board repeal, dissolves the Lease Cost Review Board and requires a yearly report on approved leases be sent by the ADOA director to the governor's office and the JLBC rather than the Joint Committee on Capital Review. And with that, I'm happy to answer any questions.
Ms. Stallman, your committee had a lot of thoughts on this bill.
Yeah, thank you. Thank you, Madam Chair. Yeah, our concern with this right now is primarily that right now, so the way that the lease review cost review board works is that it's a committee of 5 members who discuss in a public meeting that is subjected to open meeting laws and requirements how the rates get set. And then from that recommendation, ADOA sets the lease rate. And so what this would do is it would completely eliminate that public process. And it would give the authority to ADOA to make the recommendation. And then it's now the governor who decides the rates. So, you know, I sent an email and I'm gonna further reach out to the bill sponsor. I'm hoping that we can amend the bill to improve it because I think it shouldn't be moved from JCCR to JLBC, which is one of the things that this bill does, is it removes who receives the report. And B, I think that if we were able to, if we're eliminating this open meeting requirement for the setting of the rates, then maybe we can have a hearing in front of JCCR instead, so that public component of what the reasoning and what were the factors that they took into place when setting this rate is still exists. And it may have the added benefit where more people would be akin to that conversation if it was a hearing at the Capitol versus in this website where you have to know this review board exists. So I'm reaching out to the bill sponsor. I'm hoping that we can make these improvements to the bill, but it is for those reasons, especially eliminating that public oversight component that we had concerns with in committee, and that's why we ended up voting no on this.
Are you going to protest third read consent on this?
Oh yeah, I would like to pull it. Thank you.
And Ms. Powers Hanley.
What rates are we talking about?
Yeah, so this is these are the rates that we set for the public buildings. So that is, sorry, I can't go into more specifics, but that
square foot, lease per square foot.
Yeah, per square foot. So it's set by this lease review board. They recommend it, and then ADOA actually sets the rate. But it's done in a way, I don't actually think people are necessarily digging more into this.
Okay. All right. Thank you, Matt and Piper. We have Paulino and Stephanie, and we're going to start with HB 2407, Appropriation Child Care Services. Paulino, please.
Madam Chair and members, House Bill 2406, Appropriation Child Care Services, as amended, appropriates $92,712,300 to the Department of Economic Security for the Federal Child Care Development Fund block grant and any other appropriated funds in fiscal year 21 for child care assistance. And with that, I'm open for questions.
HB 2316, centrally assessed property valuations pipelines. Paulino.
Madam Chair and members, House Bill 2316, centrally assessed property valuation pipelines, outlines 3 circumstances for the Department of Revenue to determine the base value, to calculate the full cash value of pipeline property, and stipulates that if one of the 3 circumstances described adjusts the base value, should be adjusted in future tax years. This bill also applies retroactively starting January 1st, 2016. There's also a mirror bill, Senate Bill 1111. And with that, I'm open for questions.
Thank you, Paulino. Ms. Epstein.
Just for the sake of new members, there's a thing called tax court, and there's a company called Transwestern Pipeline that this is the 3rd year we've heard a bill from them, because evidently they can afford lots of lawyers, but they keep appealing that they should have lower taxes. So this bill is fairly okay. A key question was, will it mean that there's no more appeals or lawsuits from Transwestern Pipeline against the Department of Revenue? And the answer was, well, this is a fix like they did for the railroads, and the railroads haven't had any more lawsuits since it was done for them. So, little Arizona tax history for you.
All right, thank you for that. Let's move on to HB 2427, unused tax credit termination time. Paulino.
Madam Chair and members, House Bill 2427, unused tax credit termination time, decreases the time period from 4 to 3 years, which the Department of Revenue may terminate an unused corporate or individual tax credit, and provides guidance for management of carry forwards if the tax credit is repealed. And there's also a mirror bill in the Senate, that's 1113, and I'm available for questions.
Okay. HB 2398, appropriations, named claimants. Stephanie.
Madam Chair, members, House Bill 2398, appropriations named claimants, appropriates $191,596.85 for fiscal year 21 from various funds for relief of specified named claimants. This is an annual bill in which the legislature appropriates funds to various state departments to pay claimants that have been owed for a year or more. With that, I'm available for questions.
HB 2321, DOR, administrative procedures. Stephanie.
Madam Chair, members, House Bill 2321, DOR Administrative Rulings Procedures provides guidelines for the Department of Revenue to adhere to for issuing public rulings, procedures, notices, and administrative announcements, as well as private taxpayer rulings. This bill authorizes the DOR to issue these documents and requires them to take public comment on each for 30 days. It also stipulates that the DOR must read all feedback given and either incorporate the comment or provide a written response as to why they will not be doing so. Regarding private taxpayer rulings, the bill makes a retroactive change, allowing a taxpayer to request any taxpayer information ruling issued on or after September 26, 2008 be kept confidential. With that, I'm available for questions.
HB 2331, property tax, mobile homes, delinquency. Stephanie.
Madam Chair, members, House Bill 2331, property tax mobile homes delinquency, sets a process for how counties obtain unpaid delinquent property taxes on non-affixed mobile homes. The bill extends the period a mobile home may have delinquent taxes without the collection process beginning to 1 year from the current informal 60-day timeline. With that, I'm available for questions.
HB 2429, Tax Corrections Act of 2021. Stephanie.
Madam Chair, members, House Bill 2429, Tax Corrections Act of 2021 makes corrections and necessary conforming changes to tax statute due to changes in state and federal law from the previous year. The Arizona Department of Revenue and Legislative Council review the tax statutes for error, obsolete language, and blending problems. These recommendations are then compiled into an annual bill. House Bill 2429 corrects the current errors found by the Department of Revenue and Legislative Council. With that, I'm available for questions.
Representative Freeze.
Just for clarity, this is not the conformity bill.
Paulino is shaking his head no.
Thank you.
Okay. All right. HB 2431, DOR, bond election pamphlet storage. Stephanie.
Madam Chair, members, House Bill 2431 DOR bond election pamphlet storage removes the requirements for a political subdivision to submit copies of bond election information to the Department of Revenue and corresponding storage requirements. With that, I'm available for questions.
Okay, well done, Paulino and Stephanie. Thank you very much. And so Tracy and Victoria, you're up. Tracy, let's start with Victoria. We didn't get a chance to meet you last week. You didn't have any bills before us. Would you please say hello and quickly introduce yourself?
Yes, Madam Chair, members, hello, my name is Victoria and I am Tracy's intern. I'm a graduate student from the U of A.
Thank you and welcome to the House. And with that, let's dive in. HB 2070 adoption, original birth certificate release. Tracy.
Thank you. Good morning, Madam Chair, members. House Bill 2070 adoption, original birth certificate release allows an adult born in Arizona and adopted to receive a copy of their original birth certificate and any attached records upon written request. It also sets standards for the creation of a contact preference form and a medical history form of the birth parent that must be retained with and as part of the original birth certificate. The preference contact preference form must include indicate if the birth parent wants to be contacted by the birth child, be contacted through an intermediary, or not be contacted at all. And with that, I'm available for any questions.
HB 2119 healthcare insurance.
I'm sorry, Madam Chair, there was an amendment to this bill. I got this confused with the other adoption bill. In this amendment, it mandates that the agency, division, or attorney for the court to obtain from the birth parent who consents to the adoption, a statement that acknowledges that once the child reaches the age of majority, that the child may have a copy of their original birth certificate. It also requires the court to obtain from a birth parent upon termination of parental rights proceedings, a notarized statement that does both of the following: acknowledging the child who is the subject of the termination of parental rights can obtain a copy of their original birth certificate upon reaching the age of majority, and can provide either consent or withholding of the right of the child to review adoption records upon reaching that age. It also mandates the submission of contact preference form with an adoption certificate submitted to the state registrar, and it makes this act effective January 1st of 2022. It specifies that the contact preference form must indicate if the birth parent wants to be contacted, they must include their current name, address, and telephone number, and an alternate contact information if they wish to include that. Same goes for if they choose to be contacted through an intermediary. The birth parent must include the intermediary's name, address, and telephone number. And should the birth parent not want to be contacted, the consent form must indicate that the birth parent may change the contact preference form at any time by filing an amended contact preference form. This contact preference form must also indicate whether there is a medical history form that has been completed, and the amendment sets out what must be included in the medical history form. And it also appropriates $1 million from the State General Fund in FY22 to the Department of Health to implement this act. And now I'm available for any questions. I apologize for that.
Thank you, Tracy. All right. Let's do HB 2119, healthcare insurance amendments. Tracy.
Madam Chair, members, House Bill 2119, healthcare insurance amendments. In this bill, it makes various changes to the insurance code statutes governing healthcare insurers. For service organizations, the changes relate to assignment of benefits to a hospital and medical service corporation. It applies laws governing insurance company holding systems to service corporations and allows a corporation to pay an agent or employees any salary, compensation, or emolument without pre-authorization from the board of directors of the corporation. In terms of healthcare service organizations, it requires an HCSO to submit quarterly rather than monthly, which is the current statute, to the Department of Insurance, a list of all provider contracts that have been terminated during that previous 3 months. In terms of accountable health plans, it expands the definition of COBRA continuation provision to include statutes relating to small group health plan continuation coverage. It excludes a policy or contract made available to persons eligible for access and excludes a small employer who obtains a health benefit plan that is subject to and complies with federal statute from the state governing accountable health care plan premium rate practices. In terms of utilization review, it allows a provider or enrollee to appeal a denial of a formulatory exception for a plan covered by federal law through the process prescribed in federal rule. This bill also repeals laws relating to contracts and forms in effect prior to January 1st of 1955. It clarifies statutes relating to prohibitive acts of a person, applies to service corporations, and exempts the Department of Insurance from rulemaking for 1 year. And with that, I'm available for any questions.
Okay. HB 2047, insurance, optometrist contracts, covered services, Tracy.
Madam Chair, members, House Bill 2047 provides that a service corporation or insurer cannot set or dictate the pricing of services not covered by the service corporation or the insurer's insurance policy. And with that, I'm available for any questions.
HB 2126, rural providers, loan repayment program, Tracy.
Madam Chair, members, House Bill 2126 authorizes DHS to allow providers who work at Indian Health Services and tribal facilities to be providers included in the rural private primary care provider loan repayment program without the provision that they offer a sliding fee scale. And with that, I'm available for any questions.
HB 2258, dental board licenses, certificates, renewals, Tracy.
Thank you, Madam Chair, members. House Bill 2258 mandates that a dental professional license and or certificate will expire 30 days after the licensee's birthday every third year. And with that, and it has an effective date of January 1st of 2022. And with that, I'm available for any questions.
HB 2290, healthcare institutions, accreditations, and inspections, Tracy.
Madam Chair, members, House Bill 2290 authorizes a director to immediately report to the Board of Examiners of Assisted Living Facility Managers that nursing care institution administrators' conduct that may be grounds for disciplinary action. It also provides that a director may accept an accreditation report in lieu of a compliance inspection of a healthcare institution if the institution is accredited by an independent, nonprofit accrediting organization approved by the U.S. Department of Health and Human Services, and excludes from those facilities that can provide an accreditation report in lieu of compliance inspections, intermediate care facilities, and healthcare institutions that have been subject to enforcement action within the year preceding the annual licensing fee anniversary date. And with that, I'm available for any questions.
Ms. Fernandez.
I wanted to ask about, I don't have any questions on that one. That was a good job, Tracy. Did I miss HB 2126? I'm sorry if I did.
Did I miss 2126?
Well, I don't know. I may have.
Rural providers loan repayment plans. Yes, ma'am. We covered it. Did you have a question for Tracy?
I'll go back with Tracy. It's okay.
Right. Thank you, Ms. Fernandez. Okay. Let us go to HB 2298, medical marijuana research grants. Tracy.
Thank you, Madam Chair, members. House Bill 2298 authorizes the Arizona Biomedical Research Center to provide grants for marijuana clinical trials on the safety and efficacy of using marijuana for medical purposes. It authorizes the use of monies of up to $5 million annually for 5 consecutive years from the Medical Marijuana Fund to be used to provide medical research grants for marijuana clinical trials, and it does require a 3/4 vote. And with that, I'm available for any questions.
Dr. Freeze.
I know Tracy knows this. I need to pull this from consent because I'm going to talk to Mr. Payne about an amendment that specifies randomized control trials and looking at subjects like autism, pain, pregnancy, some language like including but not limited to. I think if we're going to invest a large chunk of money, we really should get randomized control trials, not a whole bunch of observational studies that look at databases. So I want to, and if the FDA is involved in approving randomized control trials methodology, I feel comfortable that they'll vet these applications well.
All right, thank you, Dr. Freeze. So we're pulling it. Rhonda got that. Okay. HB 2299, DHS Long-Term Care Facility Surveyors, Tracy. Tracy, you're on mute.
I'm sorry, my mouse would not let me pull it up. One moment, please. All right, Madam Chair, members, House Bill 2299 appropriates $1 million from the state general fund in FY22 for DHS to hire 13 additional full-time FTEs and long-term care facility surveyors. There was an amendment that increased the appropriation to $3.3 million for 44 FTEs. And with that, I'm available for any questions.
I'm going to make a quick comment on this bill. This comes out of the work that of my ad hoc committee with my vice chair, Tim Dunn. He is the prime sponsor of this bill. Although I would love to have 44 FTEs and $3.3 million, I encourage you to vote yes on this bill when it makes it to the floor. Okay, with that, let's do HB 2010, Adoption Health Information Update. Victoria.
Thank you, Madam Chair. Members, HB 2010 Adoption Health Information Update mandates that supplemental health and genetic records must be retained by the adoption division or agency with notice of the records to the adoptee if over age 18 or the adoptive parents. And also mandates that if supplemental information is supplied by any member of the birth family, adoptive family, or an adult adoptee or family of an adult adoptee, the division, agency, or person placing the child must notify the adoptee or the adoptive parents depending on the age of the adoptee. And with that, I am open to questions.
The bill sponsor has pulled this from third read consent. Ms. Butler, you had a hand up and then I lost you.
Madam Chair, thank you. My understanding was that the on the last bill, 2299, that the bill sponsor did accept and the committee voted on the amendment to increase the appropriation to 3.3 million to cover the 44 FTEs. So that is the current status of the bill, is my understanding.
All right. Whatever we get out of it, I will be thrilled to take. All right. Let's move back to HB 2016, Child Care Assistance, Education Training. Victoria.
Madam Chair, members, HB 2016 Child Care Assistance, Education Training allows DES to waive a portion or the entire work requirement to continue to provide child care assistance to a person who receiving full-time child care assistance to those enrolled in an accredited education program or training program, and mandates DES must review the educational or training program that is being pursued by the individual receiving child care assistance to verify relation to employment goals, and requires the individual receiving child care assistance to demonstrate satisfactory progress and report to DES. And with that, I am open to questions.
Okay, thank you all for hanging with us. 2 more to go. HB 2266, Medical Assistance Training Requirements. Victoria.
Thank you, Madam Chair. Members, HB 2266, Medical Assistance Training Requirements, authorizes the board to create a medical assistant training program that meets or exceeds any of the approved training requirements and verify the entry-level competencies of a medical assistant. And with that, I am open to questions.
All right, Victoria, your last bill of the day, HB 2292, Physician Assistants Licensure Board. Victoria.
Thank you, Madam Chair. Members, HB 2292, Physician Assistants Licensure Board permits Arizona Regulatory Board of Physicians Assistants to issue a new license to a physician assistant whose license has been previously revoked or suspended. The applicant must demonstrate to the board that they are completely rehabilitated of the conduct, the subject, or of the revocation or surrender to renew their license. And with that, I am open for questions.
All right. Well, thank you, Victoria and Tracy. Appreciate that. And with that, Mr. Bolding, I'm going to turn it over to you. Do you want to close this out, sir?
No, so we just have some quick updates that we can talk about after caucus, but no update right now. We're in caucus.
With that, caucus is adjourned.